J. John. Davis. Case number B230107. Mr. Davis, present in the courtroom with his attorney, Ms. Kara Blackney, and Ms. Caitlin Group of the state of Ohio. This matter is on today for a pretrial, and I've just been handed a motion to compel. So let's talk about discovery. Ms. Blackney.
Thank you, Your Honor. Yes, I followed that because you had stated in your entry that you wanted everything filed by 6/27. So I filed that. I have received paper discovery, but there are a few things that are still outstanding. I know there's a new prosecutor in here, so I just created this motion this morning just to have it on record.
I see. All right. State?
Your Honor, state would have appreciated a courtesy phone call or a courtesy email to ask what she's missing at this point, because the state has provided everything currently in their possession from my office. I do know there's outstanding body worn camera. I don't believe there is surveillance video. I don't believe there's anything more than the paper discovery with the witnesses' names, as well as the outstanding body worn camera. I'm not aware of what Ms. Blackney is looking for, because I was not put on notice prior to motion to compel that she was missing anything at this point in the state possession.
All right.
And Your Honor, that was discussed with the prior prosecutor. I know that they changed prosecutors. I was filing something because I know you had things to file, Your Honor.
All right. Well, so the body worn camera evidence has already been requested, and this case is fairly new.
Yes.
And so we have to give that time. And then any still photos? Do you think there are still photos?
So this is an incident where the allegation is my client went through the drive-through. Somebody used his card, but there has to be some sort of surveillance out into the drive-through or some sort of still photo that all banks have that. So that's what I spoke to the prior prosecutor about. He was going to reach out to the detective on the case and get back with me. I hadn't heard anything.
So in looking through the case, Your Honor, I don't know if there is a detective on this. It looks like a CPD officer filed these charges.
Yeah.
We made a request to CPD, and there indicated no surveillance, and also surveillance video is a third-party video system, so.
And that is,
The bank gets
if
managed.
he was working there, I think that's what I think kind of makes it a little different.
Off the CPD, yeah. That doesn't mean that they are a detective. It means banks hire CPD officers in order to stand there for security and they're part-time. Sometimes they don't even turn on their body camera when they're on certain off-duty because they're not on official technical police business.
All right. So what bank are we talking about?
Do you believe that it is the
US Bank at 530 East University Avenue.
that's correct, ma'am.
Oh. So, all right, so we'll give the state a little more time to reach out and maybe find out if there is any bank videos. I know every time I go to the bank, you look to that, you press the little button, call button for the teller, and there's a camera right there looking right at you. So, I don't know.
I have a couple cases similar to this, and there are at all the banks.
I state understands and the state does agree that yes, there are security cameras. The problem with it is if somebody has not requested them, i.e. a CPD officer who's an officer, who's just a field officer who doesn't know anything from the outs, it doesn't look like this was assigned to a detective to follow up with, which means that person would not have requested those videos and they would still be in custody of the bank. If you want to set this down for a pre-trial,
Yeah, I think that's the best thing to do, is set this down for a pretrial. And so we're going to continue for a pretrial. Our final pretrial is July 27th, so it needs to be earlier than that. And I'm going to hold the motion to come in advance.
I would like to add something else just to the prosecutor, because she wasn't aware. This allegedly happened back in 2021.
oh,
It
those
wasn't dated, died until 2023.
then
So
those
unless the officer has actually been spoken to, which is what I was waiting to hear back from, not at the beginning, then it really might not exist. So I'm just trying to figure out what exists.
okay. So Your Honor, at that point, I would bet dollars to done this video. But let's set it down for a pretrial. I will make a note to bring in the officer and see what comes of it.
That sounds great. All right, so let's go ahead and, Ms. Howard, and get a date for a pretrial before the 27th, which is our final pretrial on Davis. And this is just a setting to maybe see if there is any more discovery other than the body worn camera evidence, then, if you want to, waive your client's custody. July 12th.
I can do July 12th.
All right.
Is that enough time?
It's a PO, all I'm bringing is the PO.
All right, July 12th, 9 a.m., and, I'll hold the motion to compel in advance, all right?
Thank you.
Thank you very much. All right, anyone else?
Lynn, are you ready?
Ms. Howard, my bar is, so you can take it off.
Yes,
It was already dismissed June 20th.
yes, ma'am.
All right, good morning.
Good morning, Judge. Rolando Smith, ma'am.
Oh, thank you. This is the matter of State of Ohio versus Rolando Smith, case number B2301-869. Mr. Smith is present in the courtroom with his attorney, Ms. Hunzak, Ms. Caitlin Brewer of the State of Ohio. This matter is set for a pre-trial conference. We have our trial date, we have our final pre-trial conference date, Ms. Hunzak, and the trial date being October 16th, and the final pre-trial date September 28th. Let me ask you, do you have discovery yet?
Judge, I have the preliminary discovery, the written discovery produced back on 5/26. No video has been sent yet. I'm anticipating or hoping that the CTV iPhone camera will be sent promptly in MVR, and Ms. Brewer indicated she did not yet have the surveillance video from the alleged victims of the break-ins, so we're also waiting that.
Is there body worn camera and NPR?
So it's two separate agencies. One is Springfield Township, they will not. The other one is Cincinnati Police, and it appears that I do apologize to the court and Ms. Hunzak. It looks like there is a notation in the file that EWC exists. I don't believe we sent it to Ms. Hunzak yet.
All right,
With MVR, so that will be sent over this afternoon, Your Honor.
all right.
With regards to the rest of it, with regards to surveillance video, I'm going to have to take a look and see what we have in our system, and to make sure that we get everything that Ms. Hunzak is entitled to.
All right, thank you very much. Let's set this out about 30 days to get the evidence and for you to go to client to get it, okay? Perfect. Another pre-trial, Ms. Howard. Mr. Smith, another pre-trial? 30 days,
Would the 27th be available?
July 27th?
Yes,
Yeah. Yes. All right, July 27th, 9 a.m. All right, Ms. Hunzak, has Mr. Smith been keeping in good contact with you?
Yes, Judge.
All right, well, as long as you continue to keep good contact with your attorney, if you waive your presence for the next hearing, then you don't have to come to court. Okay? All right, thank you very much.
Thank you, Judge. Have a good day.
You too. Who do we have next? All right, Mr. Sinclair, you ready?
It's
She's upstairs.
All right, so we're gonna call this phone down.
Mr. Gaines.
Okay,
Yes, we definitely have, Katie from down, and Ms. Bolden after that.
okay,
Ms. Castellini is signing up Mr. Coates right now.
okay.
Will you turn your cell phone off? Thank you.
All right, Your Honor. This is Mr. Coates, he's out.
Oh, okay. Is this how we just call the meeting stand?
Yes.
All right, let's call Mr. Coates. This cat, oh, there's just, I was wondering where Mr. Coates was, sorry. These are the matters of State of Ohio versus Armand Coates, case numbers B 2301348A and B 2202972. Mr. Coates is present in the courtroom with his attorneys. Ms. Castellini represents him on the A number, and Mr. Neff, Gary Neff, represents him on the probation violation. Ms. Caitlin Brew is present for the State of Ohio. These matters are set today. The A number is set for jury trial, and the probation violation is set along with it. But it's my understanding that parties are ready to resolve the matter today, and I can hand plea documents. Is that accurate, Ms. Castellini?
Yes, sir.
Is that accurate in your case too, Mr. Neff? All right, thank you. Is that your understanding today, Mr. Coates? Are you the Armand Coates named in this indictment? How old are you? How far did you go to in school, Mr. Coates? Graduated high school? So you're able to read and write the English language well? Are you a U.S. citizen? Have you ever served in the military? Mr. Coates, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mrs. Castellini's signature here. Is this your signature here where it says defendant? This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after you consulted and spoke with Ms. Castellini about your constitutional right to a trial?
Yes.
Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry Withdrawing a Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. Now I recognize, well, I'm in the wrong place to be in. Who signed in red?
I did, yes,
Ms.
sir.
Brew, you signed as the defendant,
Oh, fine.
and Mr. Coates signed as assistant prosecuting attorney. So, we're gonna fix it right now.
Here, Your Honor.
Ms. Brew.
I just said where there's a blank space.
You're just gonna cross out, put who she is, and you're gonna put who you are. All right, thank you very much. All right, so now we have this. So, Mr. Coates, I I recognize Ms. Castellini's signature, who's the only one who signed the right of this. And then the prosecutor's signature up here in red, but right down here, where it says defendant in red, is this your signature above that?
Yes, ma'am.
All right. Madam Prosecutor, would you please put on the record the party's expectation regarding the plea?
Your Honor, he's going to enter a plea as charged to carrying a concealed weapon, felony of the 4th degree. He does also have a probation violation to you that I believe he will also be taking responsibility for this morning.
All right. Is that accurate, Ms. Castellini?
Yes, Your Honor.
Is that true, Mr. Coates? All right. Mr. Coates, are you under the influence of any medications, alcohol, or drugs today? Do you now, or have you ever had to manage any type of mental health difficulties? All right. Are you presently, under any type of probation or supervision in this state or any other state? Now, I know you are in this state.
Yes, ma'am. Cincinnati, another 6-2.
All right. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this guilty plea today? Are you making this plea of your own free will? Now, the state has indicated that you will be pleading guilty as charged to the single count indictment that charges you with carrying a concealed weapon, a felony of the 4th degree. Is that what you talked with Ms. Castellini about before this hearing? Did you have an opportunity to review this 3-page plea form with Ms. Castellini before this hearing today? Do you understand what it says? Do you have any questions about it? Did your attorney answer all your questions about it? Mr. Coates, do you believe that you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today? And has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the evidence that the state has against you with your attorney? All right, Ms. Castellini?
Yes, Your Honor, we spoke about that.
All right. Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any to your knowledge?
To my knowledge, Your Honor, we have provided all materials to the defense counsel.
All right. Ms. Castellini, do you acknowledge receipt of same?
I acknowledge, Your Honor.
All right. Mr. Coates, are you satisfied with your attorney, Ms. Castellini?
Yes, ma'am.
And Mr. Net?
Yes, ma'am.
All right. Now, do you understand this charge against you, carrying a concealed weapon, a felony of the 4th degree? You understand that charge against you? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being a felony of the 4th degree, do you understand that you're facing up to 18 months in prison, up to a maximum fine of $5,000? And do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand? All right. Now, Ms. Castellini, can you,
This is what,
yes, this last column says amount of PRC. If you could just put may and up to 2 years, which is what I just informed him of. All right. Now, is that something you talked to him about?
yes, sir.
All right. All right. Mr. Coates, so I'm just gonna say it again. So your attorney just fixed on the front of the page of the plea form what I just explained to you. And that is, if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years. Do you understand? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now? All right. Do you understand that if you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand that? Do you have any questions? Since this is a felony of the 4th degree, community control is a possibility, which is probation, which is what you're on, all right? Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you'd have to abide by all probationary conditions as established by this court? Do you understand that if I place you on community control and you violate the conditions of community control, then you'd be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty in this case could be imprisonment up to the 18 months that I previously discussed with you. Do you understand? Do you have any questions? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead. Do you understand that? Now, Mr. Coates, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? Knowing everything the court has discussed with you, do you still wish to enter a guilty plea as charged to carrying a concealed weapon, a felony of the 4th degree? Counsel, is there anything further before I accept the plea? May I hear a statement of facts?
Armand Coates, on or about the 23rd day of March 2023, in Lincoln County, state of Ohio, knowingly carried or had concealed on his person, concealed ready at the hand, a handgun other than a dangerous ordinance, and the weapon involved was a firearm was either loaded or with ammunition ready at the hand in violation of section 2923.12A2 of the Ohio Revised Code. And Your Honor, he is 19, so he's not legally able to possess a firearm and conceal it.
All right, thank you very much. Anything on the facts?
Yeah.
Did you hear what the prosecutor said you did, Mr. Coates? Is it true? What is your plea to count 1? Carrying a concealed weapon, a felony of the 4th degree. Let the record reflect that Mr. Armand Coates was present in court with his attorney, Ms. Castellini, and that Mr. Coates was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Coates understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Armand Coates guilty as to count 1, carrying concealed weapon, felony of the 4th degree, in violation of Revised Code 2923.12, subsection A2. Now, let's move to the probation violation. Mr. Neck, does Mr. Coates want a probable cause hearing?
No, Your Honor, as you're aware, he's pled guilty to a criminal offense, which is violation of 1 of the way public request.
All right, what's the plea?
Guilty.
All right, Mr. Coates, is what your attorney just said true? And you want to enter a guilty plea? All right, and your statement of facts on probation violation?
Your Honor, I believe it's bare minimum violation of Rule 1. He picked up a new charge. Rule 4, he tested positive for marijuana on 4/11. Rule 5, he failed to provide any work verification. Rule 10, he failed to make any payments towards his court costs. And he failed, Your Honor.
All right. What is your plea? Is that true? All that true?
I mean, my own payments.
All right, you made some
I
payments.
provided on.
Yeah, you made some payments. You just haven't made all your payments, right?
Yes.
All right, so,
Judge, another issue is, I think, when I first met him, he was telling me what he received, he just not, it's just did not provide verification.
I see.
He may have been doing what he was supposed to do, he just didn't provide verification, which is part of what he's supposed to do.
All right, but he did pick up a new charge and he did test positive for marijuana.
Yes, Your Honor.
All right. So what's your plea?
Yes.
All right, it's a finding of guilt on a probation violation. All right, is there any reason why sentence should not be entered today, counsel?
Yes, for PSI.
The PSI?
Yes, Your Honor.
Okay. You want your probation, violation to go along with the PSI?
Yes, Your Honor, I think it would, you guys for Mr. Coates and also the judicial process, which are handled together.
All right. Well, let's see. Let's order PSI. I don't think we need 30 days because, I already know about this codes. So, go ahead and start. Let's see the date. Let's do about 3 weeks.
July 17th.
July 17th.
That's a Monday, that's fine with me, Your Honor.
That will not work for me, Your Honor. I'm in Butler County that day.
Okay.
And I'll be out of town, at the 17th is my first day back, so we can go a day or two later.
What did you say to
I get back into town on the 17th,
Okay.
so if my presence is necessary, which it may be, I would ask to go later. So,
And I leave on the 20th, so maybe the 18th and the 19th, if the court has the days available.
How about the 13th?
I'll be out of town, but I don't know that my presence is necessary. I'm happy to try and Zoom if we can, but I'll just have.
I have a mediation that morning,
How about the 19th?
the 19th.
It's fine.
19th?
Wednesday, the 19th.
All right. Wednesday the 19th it is, 9 o'clock. Mr. Coates. You're in front of me on a probation violation and a new charge. You come back on the 19th, don't have a new charge. All right, we'll see you then. He'll need to go over probation. He'll need to go to probation for the court. All right, thank you.
Ms. Castellino,
I'll be right back.
I gotta give you paperwork.
I will wait.
All right. Is this Mr. Gaines? Okay, Mr. Gaines is next. All right, this is the matter of the state of Ohio versus Lance Gaines, case number B 2005920. Mr. Gaines is present in the courtroom. with his attorney, Mr. Brian Goldberg and Ms. Caitlin Group of the state of Ohio. All right, we're here on a post-conviction warrant return, community control sanction violation. And, counsel, have you received a copy of the report?
I have, Your Honor.
All right, state, have you received a copy?
Yes, ma'am.
All right. Would your client like to have a, probable cause here?
Your Honor, we can waive probable cause at this time.
All right. May I, hear a statement of facts?
Yes, ma'am. Your Honor, he, Mr. Blaster Gaines, after being placed on probation, violated Rule 2. He has since been restored to back, has been arrested and charged with felony. He was charged with possession of drugs and menacing in municipal court, driving under suspension, unauthorized use of a motor vehicle, and unlawful restraint in municipal court. And then he was charged with a short period distance, driving under suspension, and most critically stopping after an accident, as well as it looks like he was also arrested on burglary charges as well. Rule 8, he failed to report in office as instructed in municipal court date on 6/12. Then, Your Honor, he has failed to make adequate restitution payments. He's only paid $230 of the $1,618 he owes, and those are his violations, Your Honor.
All right, so that burglary C-23 CRA 9963, is that a new case?
I believe so. It looks like it may have been charged on 6/15.
Okay.
Your Honor, it is a new case, but it looks like it was actually ignored on June 21st by the grand jury.
Oh, okay, that, I was gonna say, I couldn't find it. All right. All right, what's, anything on facts?
Nothing on facts, Your Honor.
All right, ready to hear a plea?
So, Your Honor, I'm not the court prefers to handle this. The gist of this violation of rule number 2, which are all these pending charges. He actually goes back to municipal court on the remaining charges that's not ignored on Wednesday. So I don't know if the court would entertain maybe continue this matter past Wednesday to see the resolution of those charges. He is being held on, it looks like at least a $10,000 bond on those charges.
All right, let's see, this one. Yep, let's see more. All right, state any objection to that?
Your Honor, I think it probably would make your life easier to figure out what's going on with those cases before you sentence on those probation violations.
All right, so what I'm gonna do is I'm gonna enter not guilty at this point, continue it for probation violation hearing, and we'll continue it a couple weeks to see what happens on the misdemeanor cases.
Thank you, Judge. Would the court possibly consider maybe setting a OR bond on probation violation? That way, if the new cases are dismissed, he could be released pending the new court date on this matter.
Your Honor, the state would object to that because it appears that every time you restore him, he just continues to commit a crime and violate your bond repeatedly.
What's the bond in municipal court?
Your Honor, it looks like with the burglary now being ignored, it looks like the total bond is $10,000 at 10%. Yes.
All right, let's get a date, this hour, a couple weeks. July 13th, for probation violation hearing.
That should be fine, Your Honor.
All right, July 13th, 2023, 9 a.m. Let's set bond at 50,000 at 10%.
Thank you, Your Honor.
All right, anything else?
Nothing further, Your
All
Honor.
right, thank you very much. bowling shoe down, right?
Yes, ma'am.
Anything you can do while we're on bowling?
I'm going to talk to Ms. Dean and Kenzo. She filed a motion to suppress.
Yes.
For secondary trial today.
Well, yeah, she's filed a motion to file on the time, right?
That's correct, right? I didn't know if you wanted to deal with that right now.
Well, why don't you all talk about it and
Okay.
then, yeah.
Oh, Your Honor, Mr. O'Meara Grace apparently is not here, so we may have a problem later. Anyway.
Okay,
Is
well,
this county first law? Yeah. So,
Ms. Stevens, so this case is Mr. Reese. Oh, sure, and I'm gonna give you till, let's have 5 after 10 anyway. You got 6 minutes. If he's not here, Mark shall Is there a line? I think call down there and see if there's a line downstairs. Was there a line? Oh, okay.
usually with 10 o'clock settings, the line downstairs moves very quickly. We don't have to claw back and
You don't have that problem yet.
And then Your Honor, we have Ms. Eccleston also on the docket, Mr. Magnish, he's filed for the bond motion.
Oh, yeah, this is Max.
He's right here, Your Honor.
This is Max, let's do your case. This is the matter of State of Ohio versus Bianca Eggleston, case number B 2302246. Ms. Eggleston is present in the courtroom with her attorney, Mr. Magnus, and Ms. Gaten Group in the State of Ohio. This matter is on for a motion to clarify the bond. Mr. Magnus, you want to speak to your motion?
Thank you, Your Honor. Ms. Eggleston posted bond after it was set in municipal court. When we came to common pleas arraignment, the magistrate by entry added added juris monitor if requested,
Yes.
with a stay away, no contact order. There was a conversation at the time in the courtroom, and I have the transcript here. And I asked that there was no curfew on it. And Magistrate Birdie replied, no, there's juris if requested monitoring. I'm not doing EMD if that's what you're asking. And the conversation went on a little bit, but I tried monitoring for the curfew on it.
I'm sorry, like electronic monitoring put a curfew on her?
Yes. And what are your hours again?
I was employed, since I've been on this, I've lost employment. I have not been able to go to my address because, like, it's 2 miles within where the alleged victim works. I have 3 children and haven't been able to go to summer school. I haven't been able to do anything. They say I can get out Monday from 12 to 4 to look for work. Wednesday, 7 in the morning to 1, and then Friday from 12 to 4. And that was to look for work, which when I first went to UNU, I informed them I had a job. But since I'm not allowed in this 2 mile radius, I'm not allowed 75, 71.
Where were you working?
My sister has a cleaning business, JV and Family Cleaning Services. And it's like in Greater Cincinnati and Northern Kentucky. I also cook and country.
Was this a W-2 job?
She just got her business up and running, so I just started literally by only working for maybe like 1 or 2 weeks.
Oh, I see. All right, that's the job you lost.
Well, that and then cooking, I cook with my father back there, I cook with him, but, there's a bar in Kentucky, Mr. Dickey Lounge, and he wants to open it up for us, because we cook. I cook, that was my farm income before I started working with my sister, just cooking and
So realistically, the job with your sister, you can get that again because it's your sister.
I mean, yeah, but no, because, I mean, a business is a business. I probably can if I'm able to get out, but with the zones that I'm not allowed in, I'm not gonna be able to work. If it's Northern Kentucky, Greater Cincinnati.
Dan, I understand all that. What I'm asking you is, you said first that you lost the job. What I'm saying is, if this is lifted, you're able to
Yes,
get that job
yeah.
with your sister, because it's your sister.
Of course.
State,
Yes, Your Honor, several things. One, the prosecution witness and I had a conversation, we did reach out for Marcy's law to make her aware, of the bond hearing today, as well as put her thoughts and feelings on the record. She indicated she wished me to speak because she couldn't be here due to employment issues. The prosecution witness does not feel safe. She does not know this woman. She wants the conditions of bond to remain the same, to monitoring to remain the same. She's had several instances that she doesn't know if they're related to this, so she's very paranoid at this point, especially being attacked by somebody she didn't know. So,
you're on her home?
this, I believe, happened in a laundromat, if I remember correctly. Let me double check before I speak. So this happened in, yes, I believe this, you're right, it did happen in her home.
No,
So, Your Honor, this was a very scary situation for the prosecution witness. Like, handgun was involved, hence the aggravated burglary aspect of it all. Your Honor, it's a very scary situation. Now, the state will note that the singular one page that Mr. Magnus attached to his thing, not including the entirety, just attached page 10 of the decision, nothing more. Remember, this is a civil protection order case arising out of a civil stalking order, not the conditions, the preconditions of bond. This case indicates that there was a 10-foot radius that she was not allowed to be in, which is a radius that we do not abide by in Hamilton County with regards to this. All this court says is there should be some provisions to allow her to freely travel on the interstate, which again, makes sense, because if you're on the interstate, you're not going to be violating the terms and conditions of bond. Your Honor, she's not allowed to go to Northern Kentucky while these cases are pending, while she's on juris monitoring anyways. That cooking job is not a job she's not allowed to have. While the state sympathizes with this, she doesn't have a W-2 job, as Your Honor points out, as well as Your Honor, court is inconvenient, especially for those charged with crimes and those that are victims of crimes. Miss Eggleston's out on a juris monitoring angle on a very reasonable bond. She could be locked up in the Hamilton County Justice Center on these charges, considering the serious nature of these allegations. This is a very fair and reasonable bond. We'd ask the juris monitoring area remain the same.
All right. Anything last word, Mr. Magnus?
Your Honor, an exclusion zone is supposed to be generally tailored for its function. The function here is to assure Ms. Eggleston's appearance in court and to protect community and the victims. We've got no problem with the state of it, none whatsoever. There's nothing though that keeping her in unrestricted hours does to accomplish any of this. There's nothing that keeping her from going to her apartment in West End or Rhine. Yeah, over the Rhine area, when currently, based on the maps that Ms. Eggleston got from the electronic monitoring unit, includes an area that appears to be centered on City Hall. We're not asking for any issues on the areas out in, I'm not sure if it's Coleraine or Springfield Township. It appears to be right on the bottom edge of both. The board like to see maps.
No. What I think I'm gonna do, because this is an aggravated burglary. And this is F2, right?
F1, Your Honor.
F1. And the allegations are, there's allegations, but the allegations are May 16, 2023, that Ms. Eggleston forced her way into the home of the victim and assaulted the residents and stuck a gun in her face. Those are pretty serious allegations. The magistrate indicated that the bond, monetary bond, which has already been posted, was fine, so that's not an issue. But if requested, juris monitor would apply. And I have today representation by the state that Marcy's law has been complied with, and that the victim is asking for juris monitoring. So, that's gonna stay. But this curfew, there was no, indication on the magistrate's entry that a curfew be imposed. So, I don't see a need for a curfew to be added to the bond, so I'm gonna terminate the curfew portion of it.
Your Honor, just quickly, if you're going to terminate the curfew, I think the problem with that is in that just open hours, because if she doesn't have a time to come back at night, then at that point she's out all the time, because then there's no reason to even have a start date for her hours, because she could, when there's no termination, if you have a 10 a.m., you're allowed out, then she could technically come back in at like 9:59 without it's not a curfew, it's a time that you have to be back home by. Which
Well, the juris monitor is to make sure she stays away from the victim,
yes, ma'am.
period. The magistrate is clear, this is not electronic monitoring. So I'm not gonna impose any more than what the magistrate has already imposed. I'm gonna terminate the curfew. The order remains to, comply with the juris monitor, stay away from the victim, have no contact with the victim whatsoever. So just in case the magistrate didn't, explain it to you, if you walk into a McDonald's and the victim is there, you have to leave immediately. Understand? If you in Kroger, you have a basket full of food, and the victim walks in, you gotta leave. You understand? All right. Anything else?
You know, we would wonder if you would be willing to consider letting her go home to the Finley Market area. Within one of the zones she was told to stay out of.
Well, isn't that close to where the victim lives?
I believe, unless I misunderstand, I think the victim lives out in the Skyline Acres area, that there may be, we actually have two victims here, the way the law is. One for the alleged person controlling the apartment, and one for the person who claims to have been assaulted within the apartment. But so one of them appears to have what I think is a job in the city hall area, which is, I believe, about 3/4 of a mile from where David's home is by Finley Market. And I'm just going to suggest, as long as you stay north of Central Parkway, that shouldn't be an issue for a problem.
So your home is where?
My home is on Elm Street, and they said that,
And you have an apartment
yes,
there in
ma'am,
your name.
yes, ma'am, I lived there for 8 years, I'm a single parent with 3 kids.
I see.
Not been able to stay home, haven't been able to go there. My kids haven't been able to go to summer school because they get picked up from there.
All right. Well, I'm gonna allow her to go to live in her own apartment, but she has to definitely stay away from City Hall. She has to stay away from the business. All right?
And the other thing I would just ask is for the record, may she drive on the interstate as long as she's not following somebody. But they've been telling her that to get,
Well, he said I'm not allowed to take anyway unless I get permission.
okay, but, like, very wonderful. What's the back location?
That's where my dad is.
Yeah, her father lives, in Covington, and the
Well,
roof,
she can't go to Covington. Who's she gonna come to?
her father lives there, Your Honor.
Okay.
And some of the jobs that she would be given would have her working in Northern Kentucky.
Some of the jobs she might be getting,
Well, yeah,
because she doesn't have them today.
it's a family cleaning business, Your Honor, that goes to various locations. And again, I'm just gonna ask that travel on an interstate, even if it goes through the exclusion zone, as long as she doesn't stop and isn't directly traveling somebody who's protected here, be allowed.
I don't mind highway driving, Your Honor, it's the going to Northern Kentucky for speculative jobs at this point.
Yeah, so sure, she can travel on the interstate, but I too have an issue with going to Kentucky. So this time, and maybe we'll expand it to that at some point, but right now, she cannot. So she can drive on the interstate, all right?
Thank you, Your Honor.
All right, and she can return to her home, and the curfew is terminated.
I will write up an entry for the court to
The
sign.
juris monitor raises that. All right, thank you. We had a pretrial on July 19th So I'll see you back here July 19th at 9.
Thank you, Ron.
Thank you. All right, Mr. Reese, I'm gonna call this focus on. This is the matter of State of Ohio versus Omarion Reese, case number B2300153. Ms. DiVincenzo present for, Mr. Reese and Ms. Caitlin Blue for the State of Ohio. This matter is on for jury trial today. And Ms. DiVincenzo, is your client present and you ready for trial?
Your Honor, my client is not present. At this point, we are not ready for trial. As we previously discussed at the beginning hearing, I'm going to start a bench trial with Judge Strickland this morning, which is still scheduled and set to go. Additionally, I did file a motion to suppress on this case for Mr. Reese, as well as a motion for.
All right, thank you very much, State.
Your Honor, he's not here, so we couldn't progress anyway. We'd ask for a warrant to be issued. He was supposed to be here today for his jury trial setting.
All right,
State was right, Your Honor.
case to issue $50,000 straight and secured. And, Ms. DiVincenzo, you want to stay on the case?
Yes, Your Honor.
All right, and then what we'll do is when Mr. Reese is, upon his rest, we will deal with your motion in setting a new trial notice. Okay? Thank you.
Okay. Your Honor, maybe do one briefly before we do this.
Yes.
Maybe do Kenneth Shepard.
Shepherd, okay. This is a matter of State of Ohio versus Kenneth Shepherd, case number B2300197. Ms. Madison Mary for Mr. Shepherd and Ms. Caitlin Blue for the State of Ohio. Ms. Meredith, this is set for jury trial today. Are you ready?
Your Honor, we were going to see today, the state offered, and actually a misdemeanor in the 4th degree, which I'm sure Mr. Shepherd wanted to take, because he's willing to take, something else. He's not here this morning. I don't know where he is. I have called and texted. Him and I normally have great communication. We usually talk quite frequently, so I'm surprised that he's not here. I don't know if something's going on. He just hasn't been able to get in touch with me. I would ask for, if you would consider, given the fact that this is going to be a misdemeanor plea, if we could set it for a plea, and in the meantime, I will do my best to make sure he gets here next time. Like I said, I'm very surprised that he's not here, given the communication that I have had.
Well, it's set for trial. Ms. Brewer, what are your thoughts?
Your Honor, we had made a plea offer on this. My thought is if Ms. Meredith thinks she can get a hold of him, maybe we set it next. I want to say next week because we're busy on Thursday and Friday.
Yeah.
And,
Okay.
or do we issue a KPS OR and then he gets recited and just comes back to court rather than doing a full bond on him? I know it's not the best solution.
Yeah. So, then you haven't even had a chance to talk to him about the plea, right?
No, he knew today that we were probably going to plead, he just didn't know what to. So he hasn't been updated on what I was told today.
All right. I'm gonna set this plea within 2 weeks. If he's not here, take a solution.
Okay.
All right. Since we have a little time on the CD trial. All right. Ms. Howard, the plea date. Should be the date. I'll bring it back. Yes, ma'am.
Thank you. Ms. Howard, you're just proceeding. Please, whoever you do.
That's fine. Keep that. She said a couple of weeks.
She said, I think she said 2. Which puts us the week of the 4th, so I don't know how we're scheduled.
Next week.
The Oh, you're right, I can.
No, it's a long, well, if you're taking Monday off, it's a long, yeah, you're right. Of which I will be taking.
Does the 12th work? The Wednesday?
What is it going to be for?
Please.
Perfect.
7, 12, 14.
Yep, you need to sign Okay. Yes, thank you.
I saw him across the hall, like,
Who, Mr. Bennett? Yeah, he did come in, let me take some right now.
I have nowhere else to be. At this time.
I didn't check.
Do you? That's.
He's not here. So just certain reasons.
yeah, these are hers. She can decide. Okay. Did you grab the door? Did you find out?
Mr. Kennedy,
Yes, Your Honor. I gave him a copy.
looks like, Mr. Del Torre.
Del Toro? Yes.
Yeah, he completed everything,
Yes, he did.
and, is he here?
He's not here, Your Honor. This was originally Mr. Freeberg's case. I have called back, left him a message on the phone that this is a year ago, and emailed Thursday a year ago. I've yet to hear back.
All right, this is ILC, and I have a report your email, adult probation to John Schwind, SCHWIND, he's a probation officer supervisor. He says that Mr. Del Torre completed everything, in the 1 year supervision. He's complied with all standard supervision. He's completed drug treatment and support services. He completed 5 hours community service, and he paid all his probation fees in full. He had no violations filed, and so probation considers him to be successful, as I, and so I'm prepared to dismiss this case against him if there's no objection by the state.
Thank you, Your Honor.
Thank you, we'll do an entry.
Thank you.
Thank you so much. signature. You give me an IL signature. Oh. Oh, there it is. No, I got it wrong.
That almost needs to be framed as a judge, but like everything.
That almost needs to be framed.
Yes.
You don't get,
I'm like, check, 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 check.
you don't get too many of those, right? All right, I am finally ready for this forward. This is the matter of State of Ohio versus Sarah Boland, case number B2102303. Ms. Boland is present in the courtroom with her attorney, Mr. Jonathan Sinclair, and Ms. Caitlin Booth of the State of Ohio. This matter is set today for a pretrial, but it's my understanding the parties have reached an agreement regarding this, how to resolve this matter. I've been handed plea documents. Mr. Sinclair, is this how your client wishes to proceed today?
Yes.
All right. Is that accurate, Ms. Boland? All right. Ma'am, are you the Sarah Boland named in this indictment? How old are you, ma'am? 42. All right. Mr. Sinclair, if you wouldn't mind moving that microphone closer to her, great. Yeah, there you go. Thank you. Ms. Boland, how far did you go to school?
8th grade.
All right. Did you ever attain your GED?
I was one problem away from getting my GED.
All right. Is that something you still desire? All right. Are you able to read, write, and English language well?
Absolutely.
Are you a U.S. citizen? Have you ever served in the military? Ms. Boland, I had in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Sinclair's signature here, but right here, ma'am, where it says defendant and there's an X here. Is this your signature? This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I am waiving or giving up my right to a trial. I don't want a trial. Is that your understanding of what you're doing when you sign this form? Did you sign this form after consulting with your attorney about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand, ma'am, a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entry of Plea of Guilty. On the 3rd page, there are signatures. Good job, Ms. Brewer. You signed correctly.
There's a blank signature at the end of that document, I'm signing.
All right, so there are signatures on this 3rd page. I recognize Ms. Brew's signature here at the bottom in red, Mr. Sinclair's signature is bar number right above, but right above that, where it says signature of defendant, is this your signature, ma'am? All right. Ms. Brew, would you kindly put on the record the party's expectations regarding this plea?
Yes, ma'am. She is going to plea as charged and then speak to your honor about sentencing.
All right. Mr. Sinclair, is that accurate?
Yes.
All right. Is that your understanding too, Ms. Boland? All right. Ma'am, are you under the influence today of any medications, alcohol, or drugs? Do you now, or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community-controlled supervision in this state or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything if you enter into this plea of guilty? Are you making this plea of your own free will? Now, the state has indicated that it's expected that you will enter a guilty plea as charged to the single count possession of cocaine, a felony of the 5th degree, Is that what you talked with your attorney about before this hearing today?
Yes, ma'am.
Did you have an opportunity to review this 3-page plea form with Mr. Sinclair before this hearing today? Do you understand what it says? Do you have any questions about it?
Yes, ma'am.
Did Mr. Sinclair answer your questions about it?
Yes,
Ma'am, do you believe you had enough time to sufficiently consult with Mr. Sinclair about your entire case before this hearing today?
ma'am.
And has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review and or discuss the evidence that the state has against you with Mr. Sinclair? Madam Prosecutor, would you please put on the record whether or not the state is providing all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, the state has provided all the defense counsel.
Mr. Sinclair, you acknowledge receipt of same?
Yes.
Ms. Boland, are you satisfied with your attorney, Mr. Sinclair? Now, do you understand this charge of possession of cocaine and felony of the 5th degree? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the single count indictment? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? And this being a felony of the 5th degree, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500? And do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control now?
No, ma'am.
Do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand that? Do you have any questions?
No, ma'am, I do not.
Since this is a felony of the 5th degree, community control probation is a possibility. Do you understand that I could place you on probation or community control for up to 5 years instead of sending you to prison?
Yes, ma'am.
And do you understand that if you are placed on community control, you would have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control and you violate the conditions of community control, you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 12 months that I previously discussed with you. Do you understand? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead. Do you understand? Do you have any questions?
No, I do not.
When you plead guilty, Ms. Boland, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it is the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights that I explained them? Do you have any questions whatsoever about your constitutional rights? Do you have any questions whatsoever about anything we discussed today? Do you understand that if you plead guilty, you are waiving all of these important constitutional rights? Knowing everything the court has discussed with you, first of all, do you have any questions? Do you still wish to enter a guilty plea as charged to count 1? Counsel, is there anything further before I accept the plea? Name your statement of facts.
Yes, Your Honor. Sarah Boland, on or about 4/28/2021, Hamilton County, State of Ohio, did know that pain, possess, or use a Schedule II controlled substance, to wit cocaine, in an amount that was less than 5 grams, making this a felony of the 5th degree in violation of section 2925.11A of the Ohio Revised Code, Your Honor.
All right. Mr. Sinclair, anything on those facts?
No, Your Honor.
All right. Ms. Boland, do you hear what the prosecutor said you did? Is it true? What is your plea to count 1, possession of cocaine, a felony of the 5th degree? Let the record reflect that Ms. Sarah Boland was present in court with her attorney, Mr. Jonathan Sinclair, and that Ms. Boland was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Boland understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Sarah Boland guilty as to count 1, possession of cocaine, a felony of the 5th degree, in violation of Revised Code 2925.11 subsection A. Counsel, is there any reason why a sentence should not be entered today?
No, Your Honor.
Are you waiving the PSI? All right. Well, what do you want to say about Ms. Boland on her behalf?
Your Honor, she is right now at 1670 Redmond Road, pursuant to Judge Bratton, Trotter Bratton sentence. She is going to complete the Women's Rewards Program. She and I talked about it before. She really does have the right attitude. She wants to take advantage of the program. And she's asking the court if you might allow her to have control as a sentence so she can complete the program. She does have an out date on misdemeanors of September 15th, which she might take it based on finishing the program at Women's Rewards.
So she's on probation in the court?
No, she was given
Just the days.
sentence, and then she's chosen to take advantage of treatment. So,
All right. And that was given in order with regard to a drug-related offense?
yes.
Okay. All right. All right. State.
Your Honor, we have no problem with her completing the treatment in jail. That seems like the most prudent thing to do. She has a drug history, unfortunately.
All right. Ms. Boland, anything you want to say before I pass sentence?
No, I just want to thank you.
It's okay. Why are you crying?
I've been doing this a long time. I'm tired.
I can tell. When I looked at you, that's what I saw. That you were tired.
And I'm grateful to be, I was accepted into that program. I'm a GCB now, and I'm grateful I was placed with housing. So as soon as I walk out the door, I have to be home. No, that's enough.
So your homelessness was it a result of drug use, or was it kind of help start?
They made it worse, a lot worse. And I've been working really close with GCB and CAP, and I got really good people on my side. I got a really good team. Yeah, I'm just grateful for the chance I've been given this time. Usually I'm like, care, just give me my sentence, I don't care what you do. I don't feel like it anymore. And I've never cried in court again.
Well, you know what? That's a good thing. It's therapeutic, right? You know, it's when you cry, it's a cleansing.
It is.
So it's okay.
Sorry.
No, it's all right. Don't apologize. It's okay. You said you've never cried before in court.
No.
You've never had a team of people support you like you have now. So it looks like things are looking up. Yeah.
I'm really trying this time. I'm keeping an open mind. It's all I can do is keep an open mind and open heart and keep praying. And I know God's going to show me what to do.
keep doing all those things. Yeah. All right, well, what I'm gonna do is, I know you were in treatment through drug court, weren't you?
Yeah.
And you left.
She tried, I'm not gonna lie, Your Honor, she tried to threaten, and I tried to bring up the judge. She did lie on me in court.
Okay, well,
I know that I should.
well, I'm not talking about that. I'm
Yeah,
talking
I know.
about you were in drug court
Right,
with Judge Sanders, and you left treatment.
that was, yeah, a year and a half, 2 years ago.
Yeah, okay.
Yeah,
And
so,
then things went downhill.
yeah, and a lot has happened since then. Yeah, I'm not trying to go through again.
Yeah,
I probably tried to be, I'm not trying to. do that,
yeah, okay.
So.
Well, it sounds like, Judge Carter Bratton really, looked at your case and is really trying to help you. And so, that's why you are where you are. I want you to finish that sentence. I think that, that's gonna help you with the treatment where you are. I'm not gonna put you on probation because, you've already been through treatment for almost, I think, for a long time. And then, but you're in a place now that can really help you. It sounds like you're in a good path. So I'm not putting you on probation. I am gonna make you pay court costs, so whenever you get out and, you know, get a job and all that, you'll pay your court costs. I'm also not gonna give you a fine. I think the sentence that you're serving now is the appropriate one for even this case as well. So, but I want you to remember this feeling you have right now. Okay? Well, it's because it's a new life. That's why. It's a new way. You sound like you're ready to do something different. And that's always challenging and can be scary. So it's okay. So it looks like all the feelings that you are feeling are really normal. They're really normal. All right? So stay contacted with UCB, continue to follow the treatment regimen they've given you. You say you pray all the time, continue that, and do your best. That's really all you can do. I heard something the other day from a nun, and she said, meet your grace, do your best, and give the rest to God. Isn't that wonderful?
That's the second time in my life I've heard that, and the first time was from them as well.
Wow. Wow.
Have you ever heard of the program Take One?
Yeah, yeah.
The lady that started, her name was Sister Grace. And I'll never forget her standing to me.
Well, that must be. So I heard that the other day. It was so profound to me. So I just offered that to you again. Okay? All right. So I wish you well.
Thank you.
All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. You cannot report the process of the appeal. An attorney will be appointed to help you at no cost to you. You understand?
Thank you very much.
All right. You're welcome. Awesome.
The store right there, right hand turn.
I was over at the Seton High School, and I'm on the board of trustees there now, because they moved from the Catholic charity to the board. And so now I'm on board, and so it's a big ceremony to get the new board members in, and I was surrounded by nuns. Which was really, I'm like, I've never been so nervous in my life. They see through me, and it was so wonderful. One of the nuns said that. That was so profound. He's like, meet your grace, do your best, and give the rest to God. And she said such a peace about him. She said,
Yeah, amazing woman.
yeah. I was surrounded like 20 of them. You know, and none of them had their what do you call them? They didn't have that, they had regular clothes on, you know, but you could tell there's something different about the way they carry themselves. You know what I mean? Something special about it. They're just so peaceful. You know, it was quite nice. All right, Mr. Magnus, you brought in an entry. Let's see.
That could be used. So you realize that I do that to the best you can.
Yep, meet your grace. We're all being served by grace.
I love it.
Yeah. Great job, Mr. Magnus.
Thank you, Your Honor. If I could walk it through that, I would appreciate it, so that my client can be here with the.
That's prosecuting.
Okay. But if there was one change in it that she requested.
Okay.
I made it.
Thank you. I think we're done with that.
I believe we are, it doesn't include your recording. I'm still waiting on Mr. Magnus.
I just said that he's here. Did you tell him?
No, I asked him, was hoping we could arrive at the same time.
Yeah, you were here first, and then you came, and then you came back and he's.
Is that something on the record, Lizzie, or just?
We're just picking it.
Okay.
Yeah.
Okay, thank you. Yes. Okay. How about tomorrow? Tuesday.